This unit involves transactions with persons other than clients, or the 4-point rules. Rule 4.1 deals with truthfulness in statements to others. In contrast with the 3-point rules, which involve statements in court, the 4-point rules deal with statements out of court, statements in the conference room, in negotiations, in witness preparation, and so on. Subparagraph A says that a lawyer shall not knowingly make a false statement of material fact or law to a third person. One question, then, is what is a material fact? Comment 2 notes that this may depend on the circumstances. It is generally accepted that puffing in negotiations is okay. Estimates of price or value, or the party's intention with respect to settlement, would be okay. So, one might say, "Our widgets are the best," or "This is a paltry sum to offer our client," or "My client is unlikely to contract for such a small order of widgets, but if you could double the order, I think we could get you a deal." However, if the attorney says, "We are the only company that makes widgets of this size," when the attorney knows that that is not true, that other companies make widgets of that size, then the attorney violates this rule. Subparagraph B says the lawyer shall not, quote, "fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by the client, unless disclosure is prohibited by Rule 1.6 regarding confidentiality." Comment 1 notes that misrepresentations may be made by silence in the face of a misstatement by one's client, or by partially true but misleading statements. The attorney cannot stand mute while her client makes misstatements. Comment 3 is even more pointed. The attorney cannot stand mute after a material misstatement of fact by her client, or she may be assisting the client's fraud or crime. As you'll recall, Rule 1.2d prohibits the lawyer from assisting a client crime or fraud. If the client makes a materially false statement in a negotiation, this rule indicates that it is usually enough to withdraw. Sometimes it will be necessary to give notice of withdrawal, waving the flag. It is not okay to breach confidentiality and blow the whistle on the client unless the situation meets the standards of Rule 1.6 for breaching confidentiality. Let's consider an example. The client lies by stating, "We are the only company that makes widgets of this size." And the company representative says, "Well, we need widgets of exactly that size, so I guess we'll have to pay your price, although I still think it is too high." What should the attorney do? At that point, the client hasn't committed a crime or fraud and hasn't yet used the attorney's services to commit a crime or fraud. So Rule 1.6 would not permit the attorney to blurt out the truth, that there are other companies who make widgets of this size, but we think our widgets are superior. Instead, the attorney should take the client aside and privately explain that the deal cannot go forward based on this lie. Ideally, the client would correct his misstatement. However, if the client refuses to correct the misstatement, the lawyer cannot go forward with the deal. The lawyer should inform the opposing attorney that she is withdrawing. Sometimes that lawyer has already drafted documents when she learns of her client's fraud. In that case, the lawyer should write to the opposing side that she is disaffirming the document that she has drafted. The thing to remember is that in court, truthfulness trumps confidentiality. The attorney cannot permit his client to perpetrate a fraud on the court. He must blow the whistle on the client and correct any lies. However, in the conference room, confidentiality trumps truth. The attorney must withdraw and disassociate himself from the client's fraud, but without breaching confidentiality. Not surprisingly, the opposing party may get the idea that something is amiss when an attorney withdraws in the midst of the case. Rule 4.2 concerns communications with persons represented by counsel. The rule states that an attorney must not communicate about the subject of the representation with the person the attorney knows to be represented by another attorney in the matter without the consent of the other attorney, or unless she is authorized by law or court order to do so. Why do we have this rule? Comment 1 explains that we are again concerned with overreaching lawyers. Such lawyers might improperly pump the represented person for information, or interfere with the attorney-client relationship. This is the rule even if the represented party initiates the conversation or wants to negotiate with the opposing lawyer, according to Comment 3. Let's imagine how such a scenario might arise. Imagine you have filed a divorce for wife and served husband. Husband phones your office to discuss the case. Your first question should be, do you have a lawyer? If yes, you should terminate the conversation. What about this scenario? The client is represented by Salt Lake Legal Defenders and phones Wally Bugden, a local criminal defense attorney, for a second opinion. This is okay, since Bugden doesn't represent anyone, and second opinions are not prohibited, as Comment 4 points out. Can opposing parties communicate? What if wife and husband talk over the holidays and come to a resolution about their divorce? This is okay. Parties may communicate directly with each other under Comment 4. What if wife, your client, tells you she wants to talk to husband, represented by counsel, into being reasonable and wants your advice about what to say? Can you coach her? Yes. A lawyer is not prohibited from advising the client concerning a communication that the client is legally entitled to make under Comment 4. What about your investigator talking to a represented party? Say the victim is represented by the victim's legal clinic, and you, as defense counsel, want to interview the victim about the incident. Can you send your investigator? No. The attorney may not engage in the prohibited communication, quote, through the acts of another, close quote, Comment 4. Rule 8.4 also prohibits an attorney from doing anything prohibited by the rules through the acts of another. Note that the prohibited communication is, quote, about the subject matter of the representation, close quote. It is okay to communicate with a corporate entity about an entirely different matter. Note also that the attorney must know that the opposing party is represented in the matter. At the beginning of a case, the attorney will generally not know if the opposing party is represented. Comment 5 deals with another exception, communications authorized by law. Under the First Amendment, a client is entitled to, quote, petition the government for a redress of grievances. Accordingly, an attorney for a client is entitled to communicate directly with the governmental officials in the executive or legislative branch and is not obligated to speak only with the Attorney General. The only exception would be when the client is not petitioning the government, but the client and the government are opposed in litigation. Comment 5 also suggests that communications authorized by law may also include investigative activities of government lawyers or their agents before charges are filed. Recall that criminal defendants are protected by the Fifth and Sixth Amendments, so communication after charges are filed may violate the defendant's constitutional rights as well as this rule. However, the fact that a communication does not violate the constitutional rights of the accused does not guarantee that the lawyer has not violated this rule. If a lawyer is uncertain whether a particular communication is presented, the lawyer may seek a court order, as Comment 6 suggests. How does this rule apply in the corporate context? Comment 7 explains that when a corporate entity is represented, then communication about the case without the lawyer's consent is prohibited with the constituent who regularly directs the attorney and with the constituent who has authority to obligate the corporation and with the constituent whose acts or omissions with respect to the matter may be imputed to the corporation. Thus, counsel could still seek to interview fact witnesses within the corporation, but not any of the decision makers or any of the corporate employees whose actions are subject of the suit. Note, however, after the constituent has left the corporation, then communication is no longer prohibited. For a fun time, read Utah's version of Rule 4.2 and try to distill the differences between it and the model rules. 4.3. Dealing with unrepresented persons. When the attorney is dealing with unrepresented persons, the bottom line is to be truthful about the attorney's role. The attorney may not state or imply that she is disinterested. If the unrepresented person seems to misunderstand the attorney's role, the attorney must make efforts to correct any misunderstanding. The comments note that unrepresented parties often misconceive of the opposing attorney's role, assuming he is a general authority on the law. When an unrepresented party acts in such a way, The comments suggest that the attorney give very concrete explanations, that the attorney represents the other party, and that the other party and this person do not have the same interest, and the attorney is not permitted to give this person any legal advice. This rule goes on to say explicitly, the lawyer shall not give legal advice to an unrepresented person other than the advice to secure counsel, where the lawyer knows or should know that the person's interests may conflict with the interests of the client. Does this mean that no communication about the case can go on between an attorney and an unrepresented opposing party? No. The attorney may still negotiate with the unrepresented person. However, the attorney must first explain that she represents the opposing party and what that means. The attorney's conversation with the unrepresented person cannot be helpful in explaining the law as one would do to a client. The attorney instead must be negotiating instead of counseling in any conversation. Rule 4.4 deals with respect for the rights of third persons. This rule prohibits using means that have no substantial person other than to embarrass, delay, or burden a third person. It further prohibits using methods of obtaining evidence that violate the legal rights of another person. The comments note that while an attorney's obligation to a client requires her to subordinate the interests of others to that of the client, the attorney may not disregard the rights of other persons. It is impractical to catalog all such rights. Rule 4.4b provides that when an attorney receives a document and knows or should know that the document was inadvertently sent to him, he shall notify the sender. The rule covers any sort of document, not just by mail, but also by email or fax. Notice to the sender allows that person to take protective action. Whether the lawyer has any further obligation, such as to return the document, may be governed by other law. This is the conclusion of the section regarding transactions regarding persons other than clients.